recording in the courthouse is not a criminal action. However, failing to stop recording when directed to do so is a crime. But that's not the crime you're being charged with today.
What?
Yeah.
Man, look at, man, hell no. Hell no.
I wouldn't say immediately, because we had to talk with you, I'd say 1 minute before you left the office.
City response?
Judge, I don't think that's something I need to respond to. We have a right to amend our citation. It's actually striking something, so in theory it works toward his benefit.
What?
Yeah.
Man, look at, man, hell no. Hell no.
I don't think there's been any reason provided why we can't amend. The law allows us to amend.
Mr. It looks like you submitted this on behalf of Las Vegas Corruption Live. So what is Las Vegas Corruption Live? There was a lot of discussion about whether or not it's illegal to record in the courthouse. There was also lots of testimony to the effect that recording in the courthouse is not a criminal action. However, failing to stop recording when directed to do so is a crime. But that's not the crime you're being charged with today.
What?
Yeah.
Man, look at, man, hell no. Hell no.
You're being charged with obstructing specifically for failing to provide your information for identification purposes. Marshal Speeds testified regarding when he developed reasonable suspicion to conduct his stop of you. Now, was it nice of him to stop you after you finally decided to leave? No. But was he within his authority to do so? As he articulated, he had made observations establishing that potentially the crime of disturbing the peace had taken place. And that was consistent with the directive he received to bring the administrative order up for your review. So he conducted this stop at that time, as the city cited under the Heibel case. When he's conducting an investigation, you need to provide sufficient information for law enforcement to identify you. We provided your name, and as indicated in your own exhibit, Sergeant Speeds gave you multiple opportunities. He said, do you have your ID on you? You refused to provide your ID. Then he asked for your date of birth. He gave you another alternative to make your identification clear. You refused to provide that. At that time, based on your initial refusal to leave, when and it has been a long day, when Marshal Page directed you to leave, you were obstructing at that point. When you failed to turn off your camera, you were obstructing at that point. You were not entitled to leave unless the officers chose not to pursue an investigation. When they ask you to leave and you don't leave, now you've committed a crime in their presence, so long as them asking you to leave is lawful.
He testified that on or about May 28th, the defendant was told not to come back to the DA's office in person, that he needed to direct all communication to the DA's office to either telephone, email, or to use their victim advocate portal. Instead of following this request or this directive given by the DA's office, 2 days later, the defendant shows up in person at the DA's administrative offices. He demands to speak with Alex Chen. He's told someone will come right out, and the DA's office called the marshals. That's what started this incident.
Morning. Is Mr. Chen available? Is Mr. Chen available?
Hello, sir.
Hey.
How are you doing?
Alrighty.
So, the district attorney's office is not going to be able to help you right now, and so
Okay.
they're asking you to leave.
Okay, but she just told me somebody's coming out.
That's me.
Oh, okay. Why can't they help me?
I don't even know what your issue is.
Exactly.
You've filed a lawsuit against us, so...
The lawsuit is already filed. It'll be amended.
I know, so you can deal with us through paper.
But I haven't served y'all, and y'all are not. Y'all actually not even naming this.
Okay, you can pay someone to serve us then.
No.
We and the client can't serve us.
I'm not trying to serve y'all. This has nothing.
We need you to walk out, so please leave.
Hold on. Y'all got y'all. Who got body cams on?
We don't have
Nobody?
body cams in this facility.
Okay. So, let me step out this office, and I'm gonna start recording. And we got to take this conversation right outside the door. You want to come on? Come on now.
Officer Strong testified that before this date, he had never even seen the defendant before. Mr. Honecker testified that he had asked the defendant not to come down to the district attorney's office, that they had had a conversation on May 28th. He had asked him to make sure all communications was via telephone or email or through their victim advocate portal. 2 days later, the defendant showed up at their office anyways, despite being asked exactly to not do that. The marshals, as we heard from Marshal Page, they went up, they asked him to leave. He was asked to leave. He only stepped out into the hallway.
He needed to leave.
And at this point in time, what was his demeanor?
I think he was a little shocked, a little surprised that we were asking him to leave. He was obviously not pleased.
Was he disruptive or loud at this point?
No, he actually got up and left the immediate office.
Okay. Do you know where he went?
He went out directly outside of the District Attorney Administration office.
And when you said, you asked me to leave, did I leave immediately?
You got up and left the threshold of the DA's office into the hallway, yes.
Right. Okay. So, did I comply with your request at that moment?
My request, yes.
Okay. So I was told to leave the DA's office, not the courthouse, correct?
By myself, yes.
Okay. Okay. And are you able to tell me who else might have told me to leave the courthouse according to you?
The district court marshals.
Okay. You know exactly who?
No.
Okay. So you don't know exactly who, but you can tell me that they did?
Yes.
And then at some point he was asked to come talk to us in the hallway, to which he complied and stated he would go outside and talk with us more.
You testified that he came out of the DA's office, right?
Yeah, when we asked to speak with them. Yeah.
Right. At that point in time, do you recall if you or any other marshals in the area had asked him to leave or advised him to leave?
He was advised that the DA office was requesting him to leave, and then he was informed to leave the building, and he stated something to the effect that he wasn't going to leave.
What did you observe about my behavior when I was asked to leave the DA's office?
I believe, I thought we asked you to leave, meaning to come out and talk with us, but you may have said, I'll go outside and talk with you. I don't remember if we told you to come out and talk with us, or you said to come out and talk with us. Maybe re-ask your question, I'm sorry.
Sure. Is it fair to say that I did comply with the request to leave immediately?
I wouldn't say immediately, because we had to talk with you, I'd say 1 minute before you left the office.
And at any point during this conversation, were you walking towards the elevator?
No.
So you were still just stopped in front of the DA's office?
Correct.
And at this point, had you already asked him to leave?
Yes.
Okay. And once you radioed for Sergeant Spees to come with the copy of the order, what happened next?
So maybe a minute or two later, Sergeant Spees starts walking down the hallway towards us. When when he saw Sergeant Spees, he turned off his phone and says, "I'm leaving," and started to walk away towards the elevator, escalator, exit.
All right, so you testified that you personally asked me to leave several times in the hallway.
More than once, yes.
Sustained. So you've asked him that
well,
many times?
Next question.
Okay, go ahead and move on to the next.
Sure. Do you remember exactly when you asked me to leave personally in the hallway as testified to?
Okay, you keep on adding words. Just to be clear, I asked you to leave when you were in the lobby, not in the hallway. The hallway you started recording, and I had told you to stop recording.
Okay, so my next question is, did I hear the city prosecutor, did the court hear the city prosecutor ask you, did you ask Mr. Ott to leave in the hallway several times? You don't recall that question?
There's a couple questions there. Can you just give me one so I can answer
Do
them?
you recall when the city prosecutor, they were directing you, they asked you, did you ask Mr. Ott in the hallway to leave several times?
An objection, Your Honor, in this case, I asked if he was asked, not if specifically Officer Page asked him.
She definitely asked if he...
I'm going to sustain the objection. I think it falls under the same asked and answered basis as before. So it's been testified to that this witness asked you to leave, quote, more than once throughout the entire time that he had contact with you.
So that trespass, before you trespass someone, walk us through that. Would you have to ask someone to leave first?
Yes.
Okay. And was I asked to leave in the hallway by anyone, including yourself?
I asked you to leave.
Okay. But you said several times, your story kind of, I'm sorry, I'm getting argumentative. So you asked me to leave. We'll just roll with it. But you can't recall when you asked me to leave, right?
Oh, I asked you to leave in the lobby.
You asked me to leave in the lobby. So exactly when?
Like, you want to know the time?
Yeah. Approximately how long from me us exiting the DA office into that hallway, which was described as 4 or 5 minutes. When in those 4 to 5 minutes did you ask me to leave and I did not comply?
Okay. I asked you at least 2 times, more than once, to leave. The DA's office wanted you to leave while you were in the lobby.
Okay. So it's 2 times.
I don't recall. Yes.
But you just testified you asked me 1 time, now it's 2?
No, I said it was more than 1.
Okay, which version do you want the court to believe today?
More than 1.
Objection argumentative.
Mr. Page, do you believe it was lawful for Mr. Spies to stop me?
Yes.
What was lawful about it?
You were recording in violation of our administrative order issued by Chief Judge Weiss.
Correct.
Additionally, you did not leave the premises when I had asked you to leave.
Okay, you're going back to that, but when did you ask me to leave?
When you were in the lobby.
When I was in the lobby. Okay. You were aware that I reported that incident that day, right?
Am I aware?
Yeah.
If you
Also, we're asked about on cross-examination about whether the defendant left. In your observations, was the defendant asked at least 1 time to leave the area?
Yes,
Okay,
even the building.
And I know he asked questions about did he take steps to leave, and there was some discussion about it, but in your observations, did he ever in fact leave the building until he was asked to much later?
After the citation was issued?
Right.
Yes.
Okay. So prior to Sergeant Spies getting there, did the defendant take any, did he try to exit, was at any point restrained or not permitted to exit?
Not that I recall.
Mr. Strong, do you remember me trying to leave the courthouse before T-Spies stopped me?
I do not remember you trying to leave. I remember you walking towards the way he was coming from.
Okay. So would you say that's leaving or just walking?
For me, leaving is actually exiting the building.
Right. Okay. So we were on the 3rd floor, is that correct?
Correct. As far as what you're describing now.
Correct.
Yes.
And with us being on the 3rd floor, you just said walking out the door. So with me picking up my bag and my keys, stopping the recording, and walking towards the exit, would you say that's attempting to leave the property?
I don't recall you picking up your bag. I remember you dropping your bag at the point when you were saying, take me to jail, and the point that you went in the corner, as you said.
Yes, sir. All right. I would like to introduce an exhibit, Your Honor.
Okay. What is this?
This exhibit is going to be a video that shows I actually tried to leave right before I was unlawfully detained. As far as when I started walking towards the exit, what stopped me from walking any further?
Sergeant Spees.
Okay. And what did he do that made me stop?
He physically put his hands out and stopped you.
Correct.
On you are in receipt of Mr. Ott's exhibits as well, correct?
Yes, Your Honor.
Okay. And your copy comport with his copy containing the language at the bottom sent back, no info in the top section.
Lieutenant disagrees with it. Your Honor, this is really not a right motion at this time. This is best addressed at trial.
Okay.
The same thing with obviously, Your Honor, the supplemental exhibits. Judge, our position also that the citation, on the citation motion, Judge, if we look at the citation that I have, and I think that we provided the discovery, the place, date, and time are all provided. The citation is not defined.
The place, date, and time are all provided. Citation is not defined.
Judge, for those reasons, we believe that the motion should be denied and the case just proceed.
Okay, see, on your you are in receipt of Mr. Ott's exhibits as well, correct?
Yes, Your Honor.
Okay. And your copy comport with his copy containing the language at the bottom sent back, no info in top section.
Brief comment, Your Honor. It does, Your Honor, but it also includes the time, date, and place on my copy. So I'm a little confused as to what that is. But my copy of the citation has the correct time, date, and place.
Okay. And so that doesn't change your position?
No, it doesn't.
Okay. And, okay. Mr. Ott?
Yes, sir.
What's your response?
My response is I'm not sure how they're able to alter a ticket after I've been issued it. This is the original copy. Absolutely nothing filled out up top here. And during discovery, it was filled out here almost 4 months later. This ticket didn't even get entered into the court system until roughly 90, 100 plus days after issuance. I asked them to submit it several times to the clerk. They never did until I kept pressing. But really until the default date came. So I feel like these tickets are unlawful. And I refused to sign them. And according to NRS 171177, I should have been brought to the magistrate.
Let me write that down. What you said, 171 what?
.177.
Okay.
I refused to sign the unlawful ticket. I should have been brought before a magistrate according to the law.
Okay.
That was never done. So, yeah. But as far as the motion to dismiss, the probable cause is not there. These tickets, they don't match what I have here.
Okay.
They were offered back to them to alter evidence. I'm pretty sure that's somewhere along the lines of tamper with government documents, but I could be wrong.
It's been presented.
Okay.
Would you like to schedule for pre-trial or trial?
I'm ready for trial, but I do have a general question.
Okay.
At what point will the motion to suppress be ruled upon?
So the city's going to have a chance to present their case in chief.
Okay.
You can renew these motions at any time that you feel it's appropriate. And if I feel it's appropriate to rule on them at that time, I will. You've lodged your concerns, you've lodged your defenses. I agree with the city. It's not right to rule on these yet without any evidence having been introduced because there's a material dispute of fact. So at the time of trial, we'll proceed forward. We'll give the city a chance to present their evidence. And at any point in time, if you'd like to renew your motion, ask for the rule during the trial.
Yes, sir.
If it's appropriate, I'll make a ruling. If not, I'll continue obeying my decision.
Okay. I do have one more question, if I may.
Sure.
Is it lawful for the city or prosecutor to send evidence back for alteration without me knowing?
can't find that section, get some more information from the city about where they're talking about it.
Yes, please.
On my copy, it's listed under violation number 2.
Is that what's originally? No, right.
This is the citation that, yes.
Okay.
So we're just striking the last one. So when they wrote it, they had 2 parts to the information. It's not recorded. We're striking the stop recording part.
Okay. Yeah, I'll post that.
Okay. And what's the basis for the opposition?
I feel like that would weaken my case because this whole thing started with the illegal recording.
Okay. City response?
Judge, I don't think that's something I need to respond to. We have a right to amend our citation. It's actually striking something, so in theory it works toward his benefit.
What?
Yep.
Man, hell no. Hell no.
I don't think there's been any reason provided why we can't amend. The law allows us to amend.
Okay. So, Mr. Roth, the city can amend a criminal complaint at any time prior to ruling by the court. So I am going to allow them to make that amendment. I'm going to strike that by interlineation unless you propose amended complaint.
No, Your Honor, just by interlineation would be appreciated.
All right.